might be the good segue into the big tech censorship and immunity and the lawsuit. Let me just go to my notes. The lawsuit that is being brought against Vimeo by a church not-for-profit and an individual who has seen all of his content on Vimeo taken down because 5 videos dealt with something. I had to write this down. I've never heard of it. Sexual orientation change efforts, SOCE in the lawsuit. And a brief overview of the lawsuit is the individual's name is Doman, Church United, suing Vimeo because Doman apparently was, or I don't know how you qualify it, was homosexual, believes that he has become heterosexual, leads this or is a member of this not-for-profit church, has been putting up content on Vimeo. And they put up 90 well-produced videos, apparently, 5 of which dealt with sexual orientation change efforts, his journey as an individual. Vimeo not only took down the 5 videos, took down all 89 other videos and banned this not-for-profit from the platform. They sued Vimeo, obviously invoked Section 230 immunity. Did they invoke it? They invoked Section 230 immunity. And the argument was made as to why they should not benefit from 230 immunity. And they raise a good argument. It's one we've touched on, but I don't think we've actually ever gone into the full nuance between Section 230 C1 and Section 230 C2. I forget exactly what it is, but there's 2 provisions in the immunity provisions, what we typically regard as refer to as immunity. One is immunity for third-party content, and the other is immunity for their own actions in removing content. The former is what, as alleged in this argument brief, absolute immunity. Absolute immunity for third-party content if they have a certain system in place to try to remove it, but they leave some up. Their own removing of content has to be based in good faith. And this is where the lawsuit alleges that Vimeo's conduct is not in good faith, and it discriminates based on sexual orientation and other protected aspects. I think that's a fair assessment of a fair summary of the suit. If I missed anything, let me know. What's the status of this, and what are your thoughts on where it goes from here?
So the big news this week was they had originally filed in California. The case got moved to the Southern District of New York, where the Southern District of New York dismissed applying both Section 230 immunity grounds. And what was unique here is the intersection, because you have laws on the books that say you cannot discriminate based on sexual orientation. You cannot discriminate based on religion. And here, the question is does Section 230 even give immunity for discrimination based on religion, or discrimination based on gender, or discrimination based on race, or discrimination based on sexual orientation? And the district court said, Section 230 trumps everything. You now have immunity. You can be bigoted. If you're big tech, you can discriminate against anybody, anywhere, any place, anytime for the worst possible reasons. So that was the first big thing, was how does Section 230 intersect with these other anti-discrimination laws? The second component was the bifurcated aspect of Section 230, as you note, which is one was about third-party content. The other was about its own content or its own decisions, not third-party content, but regulating any content on its platform. And of note, originally the statute talked about all the things that are outside of First Amendment protection. So it was talking about obscenity, it was talking about those kind of things. And then it uses a comma and uses a phrase that I interpret to mean "and like things." Instead, it's so big tech, and a lot of the courts have been very accommodating, have just dramatically expanded that to mean anything big tech feels is disagreeable. This was one of the points that Thomas made. He's like, Section 230 never should have been interpreted this way, because it's not being read in the words it was written in. But they lost the Southern District of New York, went up to the Second Circuit Court of Appeals, initially lost, filed a petition for rehearing with the same panel, and that is almost never granted, but it was granted this week. So, and I think it was because this is where the comments of the press secretary, the comments of the president, these activities in other settings, Trump bringing suit, even if it's not a great suit legally right now, good for the court of public opinion, because it's more and more courts saying, okay, and Thomas issuing his multiple dissents on this subject, dissents to the granule of cert. So it's not like the rest of the judge court went against him. It was just him saying, here's the roadmap. This needs to be reexamined. It tends to come back. It's a confluence of effects back on the courts. And now you have a court doing something they almost never do, which is hold on a second. Maybe we made a mistake. Did we really mean Section 230 is this broad? Did we apply the right sections? I mean, why did we apply a section that only deals with third-party content to a legal claim that has nothing to do with third-party content? Maybe that's a mistake of the judges. But it shows you how reflexively pro-big tech all the federal courts have been, and most state courts have been too. There's like, oh, it's big tech, must be Section 230. They don't do a meaningful analysis anymore. They've gone far away from it. It's like when we were talking about the case earlier about criminalizing COVID information. This is how the government and big corporations win. They create a case that has bad facts that creates bad law. That bad law becomes so enshrined over time that everybody in the court system just assumes it to be the correct law, never really doing any meaningful underlying analysis of the policies involved. So it's a big case because of what does Section 230 really mean, and how does it interrelate to anti-discrimination statutes? And
I was going to say, I mean, you already said it, but this seems to flesh out Thomas's roadmap in his dissent almost by structure of the lawsuit itself. It goes through the history of Section 230 as Thomas laid it out. It then distinguishes between the absolute, what has been regarded as absolute immunity for third-party content versus, not qualified immunity, but rather good faith conduct by the platform.
That's kind of the
itself.
definition of qualified immunity, is right phraseology. It's the most analogous.
And it is so. I mean, I said on the one hand, they read that decision and they laid out Thomas's roadmap in the pleading. And they might have been listening to us. There's a few cases tonight we're going to talk about where I think if people are not listening to you, Robert, and I say listening to us, but listening to you, it certainly sounds like they are. First question, actually, why did it get changed from California to New York? And then how does the New York court interpret the California law? Because the Unruh Act is still going to apply or still at issue in this case?
Yeah, potentially, because of so it's just terms of service, venue provisions. So all these big tech companies in their terms of service require you, as a condition of using their service, to agree to any dispute being resolved in a particular place. Sometimes it's arbitration, sometimes it's a state court, sometimes it's a federal court, but also imposing a venue provision on it. I mean, I've represented, I can't complain about it too much because some of my corporate clients, I do this, I pick a venue that is going to be undesirable for the plaintiff trolls to be able to get to. Or if they do get to, they're not going to like it when they're there. So but that's what almost all of for most big tech, it's Northern District of California terms of service. This is a problem that Trump has on some of the defendants in the case he's brought in the Southern District of Florida. In this particular case, Vimeo has a terms of service that requires any legal action against them related to their service be brought in the Southern District of New York. And that's why it got transferred.
And SDNY, I guess we've talked about it, but so now it's going to be reheard by a panel of how many judges? 3 or the full panel? What would be a full panel? 9 or 11?
I think what I saw was just the original 3 at this stage. It said petition for rehearing was granted, but it only listed the 3 judges. So that were on the original panel. So I presume it's the same panel, and that's even more rare than a petition for rehearing en banc. Or I think how do you say it in French?
I say en banc with a silent C, but I guess at some point
you're probably right. Here in the States, always say, en banc. It's like Lafayette. It's not Lafayette in Georgia. It's Lafayette. But it doesn't look to me like. But it's even more rare for a panel to say, you know what, we just screwed up in that opinion we just issued. They never do that. It's like a 1 in a million long shot. So for them to grant it means this is why I always say the court of public opinion matters. No matter what happens in the court of law, keep hammering away in the court of public opinion because judges are listening as much as anybody else. And this case is testament to it.
Geez, I'll share the link. I just have to remember to do it. It's a great read. It's extremely well drafted, extremely well motivated, and compelling. But I'm on that side already, so they don't need to work hard on me. But they got to work hard to get the same judges who just said no to say yes this time around.